going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got multiple sovereign citizens. I decided to do a little compilation for today. It is the weekend. Court is slow, if not close. So, you know what? I just thought I would just throw a bunch of my favorite sovereign citizens at you. So yeah, let's go. These are all these sovereign citizens that did happen this year, and there are a lot. So I just picked a couple of my favorites. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Court is now on the record in City of Conneaut versus Amber McKenry, 24 TRD 819. Ms. McKenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McKenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McKenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McKenry is now turning herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McKenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McKenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McKenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McKenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I did. I exited the courtroom and asked a police officer and probation officer.
Who has the indemnity bond? Where's the bill of particulars?
The
Because I
bond is
did not receive it.
the warrant is being executed, you're being taken into custody, take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down to
For
the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Stop fighting.
No, this is a false arrest.
Okay, relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi. What am I being arrested for? What am I being arrested for?
Well, that one was fun. That was a good way to start off the video. Yeah, those darn court pirates, they kidnapped her. Man, you know, she did get out a few hours later and she posted a video on Facebook. I know Lone Wolf played it, Team Skeptic played it, so go check out their channels if you want to see her completely go off the rails and explain why she's right. Oh, it's as bad as you would think it is. All right, let's move on to the next sovereign citizen.
Coming back, we'll close the room.
I get the impression that he may be filing a special appearance on behalf of a sovereign citizen.
Ducky. Okay, we've got Mr. Myrick back. This is 25-00183. People of the City of Berkeley versus Kamashu Myrick.
Magistrate, I'm just going to acknowledge my presence for the record. Patrick Agnick. I'm here as appointed counsel on behalf of the arraignment.
All right, I do want to pause it for a second. I did not point this out the first time that I covered this guy, but I want to take a moment to appreciate the sign that's behind this attorney. Free speech doesn't mean careless talk. Thank you, attorney. I appreciate that sign. Okay, moving on.
Back at this morning, I did speak to Mr. Myrick in private. I did explain to him he does have the right to counsel. I explained to him, obviously, that right. He's indicated to me unequivocally that he does not want counsel. Mr. Myrick, is that a fair statement?
That is a fair statement.
So with that said, I'm here and present, but with that, I believe Mr. Myrick will address the court on his own behalf.
Mr. Myrick, you have the right to decline counsel. You also have the right to change your mind. If you do, just notify the court.
He also has the right to appear sideways, which he is exercising to the fullest.
Yes, sir.
You've been charged in this citation that was issued on the 22nd day of January at about 5:58 in the morning with driving in the city of Berkeley on Henley near Franklin Street while your license to do so was suspended. Driving on a suspended license is a crime for which you could be incarcerated up to 93 days and or fined $500. You have a right to a trial. Trial can be before a judge or a jury. You can act as your own attorney or you can be represented by counsel. If you cannot afford to retain your own attorney, an attorney can be appointed for you. You'd have the right to confront and cross-examine the witnesses against you. You'd have the right to testify yourself or not to testify. In the event that you choose not to testify, your silence cannot be used against you. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. The court's going to enter a plea of not guilty on your behalf.
No, sir. I don't even understand the charges here.
The charge is driving a car on the streets of the city of Berkeley while you're not licensed. You're suspended. That's the allegation.
Well, I totally understand, and I would love to plead, Your Honor. But before I have some questions on the record before moving forward and concerning the subject matter of the jurisdiction and the nature and cause of the action that's brought against me.
The nature of the cause brought against you is a criminal charge
Okay.
alleging that you were operating a motor vehicle on the streets of the city of Berkeley while your driver's license was suspended by the Michigan Secretary of State. That is the nature of the charges brought against you.
Thank you, Your Honor. For the record, are you saying that these are criminal charges?
Yeah.
Okay, Your Honor. Further, that brings a little bit more confusion for me because under the Constitution, there are two criminal jurisdictions. One is under the common law, and the other one is under admiralty, and that's a military tribunal venue. And under Article 1, Section 8, Clause 17, which one of these criminal jurisdictions am I being brought on charges under?
Mr. Myrick, your perception as to the nature of the Constitution and its implications is grossly distorted. You're not dealing with reality.
Objection, Your Honor.
You can object all day long, but the bottom line is that what you are alleged with doing is a crime, and you are facing criminal prosecution here with a potential jail sentence of 93 days. Now, this isn't complicated. If you want to come up with words that don't make sense, keep talking. But the bottom line is that there's no correlation with what's going on here and admiralty law whatsoever. And the common law is a civil concept. We have statutes in the state of Michigan, as do all 50 of the states. The federal courts have statutes, and common law is a civil thing. There's no common law crimes.
Exactly. So you've ruled out the common law, Your Honor. So the other criminal jurisdiction that I can be brought in charges under is under admiralty, and that is a military tribunal.
There is no basis in law or fact for the conclusion that you stated, sir.
Your Honor, you
need
said
a
that
lawyer.
I'm under a criminal. This is a criminal charge, correct?
Yeah.
So which of the two criminal jurisdictions?
You haven't heard what I've said, sir. This is not a matter of having the two choices that you have spoken to.
Wow.
You are misreading the Constitution of the United States, the Constitution of the state of Michigan, and the statutes that are brought against you here. There's nothing to do with admiralty. You weren't in a boat.
Well, Your Honor, you two have a sworn oath of office, correct?
I am sworn to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the statutes related thereto. And that means that I'm not going to.
So you do have a Sixth Amendment obligation to inform me of what jurisdiction.
And I think I have done that. I have told you that the people of the city of Berkeley have brought charges against you.
Well, Your Honor, the people is not a person. If I'm being brought up under criminal charges, there needs to be a corpus delicti, which there isn't. So I'm asking you.
Do you know any other legal words? Why don't you just mix and match them here?
Well, this
maybe
is,
you could get a Department of Labor form and read a couple lines of that into this record too. Or maybe you'd like to do it with the probate code. But the reality, sir, is that you've been charged with a city ordinance violation. It's clear what the ordinance says. It's clear what you've been charged with. You have a right to be presumed innocent, and you have a right to a trial. We're going to set this for a pre-trial before the trial. You'll be notified by mail. Do you still live on Mendota?
I do, but I have.
What is your phone number?
I'm not issued a plea, Your Honor.
I have entered a plea of not guilty on your behalf.
I object.
What is your phone number?
You cannot
sir?
enter a plea. I do not. I have not entered a plea.
I just did.
Your Honor.
What is your phone number?
There is no plea that you can enter in because I didn't voluntarily enter in the plea, Your Honor. I'm asking you, Your Honor,
You want
what
me to enter a plea of
jurisdiction
guilty?
under the two jurisdictions that I'm
There's
being
not two
charged under?
jurisdictions. I
There's
don't know
only
how
two
you've been
jurisdictions
misled
that
to
I can be
believe
charged
that
under
there
under
are.
the
No,
Constitution,
that's
Your Honor.
Mr. Myrick. That's what your conclusion that there's only two jurisdictions here is absolutely without merit in
Your Honor,
fact
you said
or
that this is
law.
a criminal charge. I'm asking you, Your Honor.
I'm asking you what your phone number is. Let's get down to basics here. You're making this very hard on yourself.
Your Honor, I
What's
have
your
the
phone
right
number?
to assert my right, Your Honor, and
What
I am
is your
asking
phone
you,
number?
Your Honor.
What is your
What
phone number?
my phone number, Your Honor, is
Yes, I'd like to know it.
Your Honor. We haven't even established what jurisdiction we're in.
I have established that. I told you it's the people of the city of Berkeley that brought the charges against you.
Your
You've
Honor,
said that three times now.
You stated on the record that these were criminal charges, Your Honor. I need to have
Correct.
an understanding. By the Constitution, Your Honor, there are only two
Where
criminal
does the
charges that I can be
Constitution say
brought
you
under.
have to have an understanding?
Say again, Your Honor.
Nailed it, Judge or Magistrate. Sorry, I apologize. Yeah, I really wish more judges would call sovcits out for this. We're like, I need to have an understanding. No, you don't. It is not the court's responsibility for you to understand it. They can't force you to understand anything. They'll read you. They'll read you the charges, which he already did. You were driving without a license. I don't know how you don't understand that. That's worrisome. Yeah. Okay. Let's keep going.
Where does the Constitution say you have to have an understanding?
By the Sixth Amendment, Your Honor. The
Sixth Amendment says you have to
the right
understand. The Sixth Amendment can't make you understand if you're being unreasonable.
Your Honor, I have the right to understand what jurisdiction that I'm being brought under, and you have an obligation to inform me of that jurisdiction, Your Honor.
Which I have done about 17
by
times.
the Constitution, under Article 1, Section 8, Clause 17, Your Honor.
Mr. Myrick, your bond is $1,000 cash or surety. It must be paid within 48 hours or there'll be a warrant issued for your arrest.
Your Honor.
That's done. We're through. Good luck.
Your Honor.
Get your own lawyer.
Your Honor, you have not given me a jurisdiction, Your Honor.
I've given you a jurisdiction 4 times. I'm not going to waste any
Your
more
Honor.
time.
Your Honor, I think you there was a disconnection or something.
No, I disconnected you. If you want to continue, come to the courthouse, sir.
Your Honor.
Come to the courthouse if you want to continue the conversation.
I would like to move for dismissal.
I would like. It's not going to be. No.
I would like to move.
You're gone.
She's a beauty, more chocolate. Oh my God.
Oh, even his court clerk got a kick out of that. Good job, magistrate. Hang up on that guy. Come to the courthouse. Pay your bond that you just talked yourself into. You have a $1,000 cash bond. Well, I think he said or surety. I don't remember, but it's $1,000 and on a driving while suspended charge. Good job, man. Good job. And I bet he didn't show up. He didn't pay that bond. You now have a warrant for your arrest. Speaking of idiots, I believe we have Judge Clark next. Hold on, let me play a minute of it. Nope. Okay. No, even better. We have the sovereign citizen on a leash. All right, Judge Clark's after this guy. All right, let's go, Judge Ricky.
Jesse Travis McGlauflin.
Yeah.
It's the state of Kansas versus Jesse Travis McGlauflin. It's case number 2024 CR 397. Mr. McGlauflin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McGlauflin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, we will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McGlauflin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in the
man must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so. So, Mr.
So
McGlaughlin,
what
I'm going
gives
to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McGlaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McGlaughlin? Apparently not.
Yeah, you need to address a point of order. As a
I've
first
addressed
point of
all of
order
the
in
points
court
of order
the
that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McGlaughlin.
jurisdiction.
The McGlaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McGlaughlin. All right, let's move
Request
on.
a copy of. I
Thank you
request a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time. All right, Virgil Fry.
All right. I still get a kick out of the fact that that guy's on a leash. Anyways, yeah, that guy. There's no words to describe that guy. He's on a leash. That's all you got to say. All right, now we're moving on to Judge Clark, and this guy takes a sweetheart deal and blows it up. Sovereign citizen. Sometimes you amaze me. You know, you think you hear it all, and then this happens. Let's go.
Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you successfully,
If you did all those
you have
terms.
to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
You ask Mr. Meredith.
Yeah, I mean, I spoke with him shortly. I didn't really get all I really spoke of, what we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it? Are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking questions.
Yeah, you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got to offer a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
We'll set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on Central.
Central Standard Time. You're on Eastern Standard Time. Okay? If you'll step over and sign a notice. Safe trip back to Gainesville. Step over right over here and sign a notice, sir.
David Seaborn.
See, sovereign citizens always want the charges dropped because of the whole victim thing. You can't have, the state can't be a victim. He's a young, so, you can ignore a little bit of ignorance. But why is he trying the sovereign citizen thing when his case is going to be dismissed? All right, let's move on. Good job, Judge Clark. All right, I thought this was it. This is the last case. You absolutely knew I couldn't do a compilation video without adding Eric Martin to it. So, Eric Martin, this was my favorite hearing of his so far this year. He's already been in court, I don't know, 3 or 4 times this year. I don't know, maybe 1,000 times last year. But this one takes the cake so far this year. Eric Martin, let's go.
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Darren on behalf of Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled an old capital letter his name.
Yeah, you're Eric Martin, in other words.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now. And under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he's told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Hello? Am I heard? No? Hello?
Yeah, do we have the prosecutor available on this matter?
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
He's in the main session now, Judge.
I'll go ahead and say what I got to say then, before the prosecutor gets a chance to say something.
So, this is on the Eric Martin case, charging as a misdemeanor domestic violence, originally placed on a personal bond. My understanding that he violated bond, and the bond was reset at $2,000 cash because he violated, I think, by having, it was, correct me if I'm wrong, contact with the victim.
Judge, Alex Winger for the people, P number P8659. Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to, he's not allowed to go to.
So, and so, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
Yes, something to say, Your Honor.
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Yes, Judge, the people, the victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right. Yeah, did you want to be heard, Mr. Burton?
Yes, okay, now, I want to add, under, not only before we get to the bond issue, the cases should be dismissed, which I did file a motion to dismiss already. The court probably just received it, because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C 1 through 6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on violation of my speedy trial right. And based on again, the court rule I just named off, I'll say it again, case everyone heard clearly, MCR 6.004, subsection C, 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not the normal excluding Saturdays and Sundays and legal holidays. That's always been followed wrongly, but it's not, like I said, it doesn't apply to speedy trial. So my right to speedy trial has been violated. The case should be dismissed. So I want that decided on first before we address the bond issue, because as long as that's granted like it should be, then the bond's no issue. But so once the decision's reached on the motion to dismiss, I just file it now. Then once the decision's on that, then I'll address the bond if it's not granted. But that's all I have to say on that for right now.
Yeah, Mr. Rangel?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been, I believe this is the third or fourth defense counsel representing the defendant, and if it would be then in the court's client to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels, and once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged, addressing bond again, that if the defendant is released on personal bond, put on a tether.
I gotta talk to.
Okay, now what he just said was, I was going to say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December is when I was arrested by Taylor cops illegally, based on no evidence, based on my brother's lying allegation that I sold him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court rule again, MCR 6.004, subsection C, 1 through 6, makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands the case, calls for the case to be dismissed. Simple as that. Everything else the prosecutor's saying is nonsense.
All right. Yeah. What the prosecutor just said was not nonsense. Mr. Martin, you are the reason why your case has been delayed, and it's not delayed. You're still set for trial on the same day. It's coming up here. It's at the end of March. That date has not changed. So your speedy trial has not been. Nothing's messed with your speedy trial except for you, and the prosecutor is 100% right. All right, now let's get into bond. This is the best part of the hearing is the bond. Oh man, Eric Martin is special. He really is.
I'm in this video and I don't understand how I got put here.
All right, we're going to put you on mute, Mr. Kerr. This isn't your case at this time.
I'm supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right, so thank you. Yeah, who's speaking now?
This is Kurt Martin, the brother.
All right, did you want to comment on this whole matter at this time, Mr. Martin?
No, no. I couldn't even I didn't even know it was today, the court. Thought that it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and so I don't have nothing really to comment about. I mean,
All right, very good.
I just want to make sure I was that you can see me and I was heard, because there's nobody that see me or nothing.
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be to a great measure caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied. I will allow a personal bond in the case of $2,500 conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're gonna need an address for you or phone number, Mr. Eric Martin, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now. Can I make objections now to your order?
I did not hear that.
I said I have objections to your order. Now, first of all, the in objection to your order, no delay has been attributed to me switching attorneys. That's false. Okay, I have not intentionally said give me this attorney over that attorney. Whatever they did, that's what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house I've been living at for 32 years. The house I've been living at for 32 years, regardless whether it's mine or not, okay?
Do you
Based on an
understand?
unsupported lie.
I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions?
That's right, because I have no other house to go to.
All right, Mr. Martin.
I have no other house to go to. And it violates my due process anyways.
Yes, so Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated he will not comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next pretrial conference. Same bond conditions.
That violates my due process. I want to appeal this now. I want to appeal this to the Court of Appeals ASAP. It all violates my due process. It violates my...
All right, thank you. That's going to end the hearing.
We'll get the court date in the mail, Judge.
Yes, sir.
All right. Thank you very much.
Thank you.
All right. Yep. That's the infamous Eric Martin. He was free. He was free for all of about 40 seconds. Just can't keep his mouth shut. And how is not able to go home violating due process? I don't understand that. Don't understand that at all. Anyways, this is my collection of my favorite sovereign citizens so far this year. Hopefully you guys enjoyed them too. I was gonna put in Mr. Johnson out of Kansas in Judge Webster's court, but I decided not to because his most exciting hearings happened last year. The only one we had this year, he called in by phone because he's currently being court-martialed by the Army. But it's still a good video, especially when you watch all three of them back to back. All right, hopefully you guys enjoyed this. This is the first compilation video I've ever done. Let me know if you like it. I'll keep going. Let me know which one's your favorite sovereign citizen, or let me know if I missed one. I could have missed one, and yeah, that's all I got. Please hit that like button. I would appreciate it. This video did take a little bit longer to put together, so I would have very much appreciated a like. That's it. Until next time, bye.